work on Friday, so I wasn't available. But I can send out an email with all the information. I'll also write it on the board. It will be on what's scheduled as the first Saturday. We just won't meet this very first Saturday. And I'll make it up at the end. I always do a makeup if I have to make the class. So you will do that time. It just won't be this Saturday. And I believe y'all have other Langdale scheduled on Saturday.
Friday.
Friday.
Property planning on changing to Friday or Saturday.
Saturday. Okay, yeah, she actually told me somebody else was coming. So.
Okay. Well, in any event, we'll send the email with the details of time and location. Yes. I'm going to talk at the end of class about the exam. I don't want to do the beginning because we have a lot to cover. I want to save it till the end. And if I forget, remind me. You'll never forget that one. Remind me at the end of class, and I'll be happy to talk about it. But one of the things that Rebecca will go over is how to prepare for the exam, how to write your outlines, how to take notes. And this will be right before the midterm. So it'll be a very good opportunity for you to assess yourself. So please feel free to reach out to Rebecca. Do you want to write your email on the board, please?
My email up here.
Thank you.
And I'd like, if y'all have started outlines or charts or something for the class, if you'll bring them on that first Saturday, I'll stay after our time because I want to look them over and sort of give you some tips. And I'll also bring what I used on the final exam, which is just a 1-inch binder that I barely opened because I knew the material. But so you can sort of start thinking about how to organize yourself. So, and my Langdale's last semester, 1 Cali and 2 got A's. I haven't talked to anyone else, so what we're doing is working.
Okay, very good. Thank you, Rebecca. Okay, any other questions unrelated to the midterm or the exam? I'll do those at the end of class. Any question on Noel Canning, on Humphrey's executor, on Myers, on the appointment power? No? Okay, very good. So our class for today focuses on an aspect of the executive power that you're all probably most familiar with in general. And this is the war-making power, the power of war. And this class in particular is one of those that really brings into focus how tenuous our separation of powers is. And specifically, what happens during the time of war. So I want to actually start with Korematsu, and we'll go back to Curtiss-Wright and the other cases first. So you're all familiar, more or less, with the facts of Korematsu. You all know what it is. In fact, before you came to law school, this is probably one of the few cases you could have named. What I want to talk about here is whether this kind of thing could happen again. So, thank you so much, Rebecca.
Thank you.
Thank you so much. So a few months ago, Justice Breyer, who's on the Supreme Court now, was interviewed, and he was asked, could Korematsu ever happen again? Could Korematsu ever happen again? And the question was framed ambiguously. Was it a question, could the president ever detain people based on their race again? Or was the question, would the Supreme Court ever uphold such a decision? Right? The question was ambiguous. I want to read you Justice Breyer's quote. Breyer said, 2,000 years ago, Cicero, who was a great philosopher, 2,000 years ago, Cicero wrote, in times of war, the laws fall silent. Or if you want to be cool and say it in Latin, intra armis silent legis. In the times of war, the laws fall silent. And Breyer said this was the court's attitude for a long time. And it was this mentality that led the court to uphold the internment of 70,000 Japanese Americans during World War II. Breyer said the court said, look, we can't run the war. Roosevelt, the president, has to run the war. And the host asked Breyer, could it happen again? Right? Could this happen again? And Breyer said, I doubt it. He said this country has developed a stronger tradition of civil liberties. Taking the opposite perspective is Justice Scalia. Justice Scalia was asked the exact same question a couple years ago in Hawaii at a lecture. And Scalia said, again, in times of war, the laws fall silent. And Scalia said, quote, "Of course Korematsu was wrong, but you are kidding yourself if you think the same thing won't happen again." Breyer said, "I doubt it would happen again." Scalia says, "You are kidding yourself if you think this won't happen again." When there's panic, this is what happens. I would not be surprised to see it happen again in times of war. So again, we have two Supreme Court justices, right? Looking at one of the most, reviled cases in the Supreme Court's canon. One says, "Nah, we're too civilized. That won't happen again." And the other one says, "Ha, who are you kidding yourself?" And, I mention this anecdote, every year. And several months ago, a presidential candidate made this lesson more interesting. So presidential candidate Donald Trump announced that he called for a complete ban on immigration for Muslims. And he was asked, "Can you do this?" And his answer was, and I'll read you a quote, "What I'm doing is no different than FDR. If you look at what FDR did, it was far worse. And he's one of the most highly respected presidents. They named highways after him," Trump said. He added, "This is a president who was highly respected by all. If you look at what he was doing, it was far worse. We are at war now. We are at war now." So whether he realizes it or not, and you can argue about this, Trump is effectively invoking the maxim, this, in times of war, the laws fall silent. If Roosevelt did it, well, he was this great president, right? He has a monument in Washington, D.C. It's one of the smaller ones, not the big ones, right? Why can't I do the same? And this is why Korematsu is such a significant case. It wasn't simply that the executive took some sort of action that perhaps went further than anything that had been done before. It's that the Supreme Court, by a vote of 6-3, upheld it. And by sanctioning the decision, they gave it legitimacy, right? They told future presidents, you can rely on Korematsu to justify other forms of executive action. Now, as it turns out, future presidents have not relied on Korematsu. But I think Justice Scalia has a better argument. You're kidding yourselves if you think the next time something really bad happens, that something different would result. You're kidding yourself. I think Justice Breyer is perhaps being a little bit too optimistic or naive, perhaps, by saying it won't happen again. Don't count on it, as Scalia says. And this is a frame that I want to introduce today's class. We'll be doing 3 major cases. I already mentioned Korematsu. The first you probably have never heard of, Curtiss-Wright and Dames and Moore. But these were all cases that arose during times of foreign conflict. Not necessarily a declared war, but some sort of foreign conflict. And the power of the executive to do stuff that Congress did not give him permission to do was in doubt. You've already studied Youngstown. Youngstown, even though it happened during the Korean War, the court stressed was not a foreign powers case. It was domestic. Remember, it involved a steel mill in Ohio. This wasn't involving a foreign theater of war. That was significant because it was domestic. But these cases concern foreign relations. Foreign relations is an area where the executive is often thought to have much, much wider latitude than that of the Congress. So our class today on Thursday and our class again on Tuesday continue this thread of the president's ability over foreign powers. One slight note. So for the readings on Tuesday on the United States versus Texas case, immigration case, I posted the reading last night. It's actually a Congressional Research Service report. When I like to teach about a pending case, there's not much to give you because the case hasn't been decided yet. So this is actually a report from the Congressional Research Services. It's pretty balanced and even. I think it actually does a good job explaining the issue. So you can download that PDF. It's not that hard to read. It's actually fairly easy to digest. But our cases today and on Tuesday assess the scope and the balance between the foreign policy powers of the president and the foreign power policies of the Congress, and whether Congress is able to check the president's powers. Okay, so any questions before we get started? Okay, this will be a jam-packed class. We got a lot to do today, so let's move along. We start with the Constitution, as always. We start with Article 2, Section 2. And Article 2, Section 2 spells out the president's powers. Now, where did I finish last time? Somewhere over there. Oh, you? Okay. Zach, you're up next. Okay. Zach, I love how this guy's pointing forward. Zach, when we began our class, right, we looked at Article 2, Section 1. It says, the executive power shall be vested in the President of the United States, right? And we said the executive power is this broad thing that's not defined, right?
Right, that's correct.
Okay, I know, right? So what do we make of the fact then that in Article 1, Section 1, they give you this broad executive power, and then Article 2, Section 2, they start defining it, saying, okay, you have the commander-in-chief, you can make treaties, right? How do we understand or reconcile the fact that at the beginning you have this broad power, and then later it says you have these specific powers? What do we make of that? Which is it? This broad, undefined power, or is it that the power only has those? I'm sorry, the president only has those powers listed.
The power, they have a broad power, but limited in these circumstances. Listed in Article 2.
Right. So this is one of the textual riddles, right, of the Constitution. On the one hand, you have this broad executive power that the president has, but on the very next page of the Constitution, the Constitution spells out he can be commander-in-chief. He has a power to make treaties. He can appoint ambassadors, receive ambassadors. So he has all these specific powers. So there's a tension, and there's not really a clear answer one way or the other. Does the president have powers that are not listed? In other words, Sheridan, if the Constitution lists these 3 or 4 or 5 powers, does the president have powers beyond those? We study with Congress, we say Congress only has the things listed in Article 1, Section 8. That's all they have. But here they list a few things for the president. Are those the only powers he has?
No.
You're right. The answer is no. But why is the answer no?
Well, from my understanding of the reading, there was kind of something where I was looking at the development of the documents before.
Okay, good. Tell me about that.
Came into play, and
Good.
so they're saying once the states, or I guess the colonies, declared independence from England, that all the states have these kind of executive powers, and the states themselves, or I guess the colonies themselves, were directly related in like foreign relations with other foreign states and things like that. And so I believe it's through the Virginia Plan that they decided, okay, we kind of want this executive position created.
Good.
However, they didn't want it to be kind of like a monarchy where one branch had like all this power. And
Very
one
good.
was like,
Excellent answer. So to understand the scope of executive powers, we don't look just to the text, right? Because the text is not fully conclusive. We look to the history and practice. And then think about it this way, right? So before 1776, all of the executive power, right? All of the power resided in the crown and the King of England. We declared our independence. Where did that sovereignty go? This is discussed in the Curtiss-Wright case, right? Where did that where did that power go? It devolved to the colonies. And each colony then had the sovereignty. But the colonies didn't keep it for themselves. They had the Continental Congress, this centralized body that had the power to make war and make treaties and make peace. So the power effectively went from the king to the colonies to this new Continental Congress. And what happened after the Continental Congress? It continued in the form of a central government through the Articles of Confederation. And the Articles of Confederation gave way to the U.S. Constitution. And who did the Constitution vest that foreign policy power with? Well, it gave some of it to Congress, but it gave the residual. It gave everything left over to the president. And this is the way to think about it. Congress has certain powers over foreign policy. I have a number of them up here. For example, Congress has the power to punish piracies, right? This is in Article 1, Section 8. Congress has the power to raise armies. Congress has the power to declare wars. Congress can provide for a navy. Congress can call forth the militia. Congress can organize the militia, right? Congress has a bunch of powers that are enumerated with respect to foreign policy. But Zulma, what happens if there's an aspect of foreign policy that's not specifically given to Congress? Who has it? Exactly right. What do we call those powers of the president? They're not listed. What does the book call them? Inherent. Very good. Implied or inherent powers. So the president has some scope of implied or inherent powers. And these are powers vested by the Constitution. These are the powers that came from before there was even a Constitution. Okay? The scope of what these implied powers are is often a very difficult question, and one the court does not like answering. You'll recall in Youngstown that President Truman argued that he had an inherent power to seize the steel mills. Remember that? That's Mirza. Mirza, do you know why the court in Youngstown rejected the argument that the president had this inherent power to seize steel mills? Why did they reject that argument?
He was exercising power beyond scope.
Who had the power of seizing property?
That was Congress, and they only seized it.
Exactly. That was a power given expressly to Congress. And where a power is given expressly to Congress, the president can't claim that he has it also. You understand that? If the Constitution gives the power to Congress, the president can't claim he shares it. He has no inherent power. So the question often becomes, and this is the issue in Zivotofsky, the Israeli passport case, or the American passport case with Israeli stamp in it, we'll read next week. Is something exclusively a power of Congress, or is something exclusively the power of the president? If it's just the president's power by himself, yes, he can do it. But if this is a power that Congress has, it's not an inherent power. So very often the question becomes, is the president relying on the power from Congress, or is the president relying on a power from the Constitution? Right? This is the question from Youngstown, from Justice Black. The president can only do that which comes from the Constitution itself or from a statute. Those are the only sources of the president's power. Okay. Everyone get the idea, this distinction between powers from the Congress, when they have these enumerated powers over foreign policy, as opposed to the president's inherent powers, which you get straight from the Constitution itself. Any questions on that? No? Okay, I'll move on. So this brings us to our first case. United States versus Curtiss-Wright. And the facts of this case are complicated because the opinion doesn't actually explain what really happened. Simply put, Curtiss-Wright was a military contractor. They made various forms of weapons during the war. This is like their, the production map where they made all these different things. And Curtiss-Wright got into trouble by selling weapons in Bolivia during the Chaco War, which, if you've ever heard of, it was a war between Bolivia and Paraguay. The Chaco region was thought to have oil, and as a result, there was massive fighting over these countries that wanted to seize this region. These are both poor landlocked countries, so Curtiss-Wright decided to support one of the sides and sell machine guns to them. Nothing new, right? Supporting one side in a war. But what happened there is interesting. So now the case is called United States versus Curtiss-Wright. Heidi, what kind of case is this? United States versus Curtiss-Wright? What kind of case is this arising out of? What happened here? Again, the case doesn't explain actually what happened, but what do you think? When it's United States versus Curtiss-Wright, who are the parties?
There was a joint resolution made.
I'm not talking about the joint resolution, the case itself. I'll get there in a minute. What kind of case is this?
Federal question. Is
No.
that what you're looking at?
What role was the United States playing in this case?
Oh, they were the plaintiff.
No, they weren't. Not the plaintiff. Alexis? What kind of case was this?
Well, I know that Curtis tried to say that the president couldn't stop.
What kind of cases? Anyone know what I'm looking for?
Criminal.
Criminal case. This is a criminal prosecution. The United States, the Department of Justice, indicted Curtiss-Wright. You may not have known this, but corporations may be prosecuted for crimes. This may be a foreign thought to you. So, corporations aren't people. They are in many respects. They also be indicted for crimes. Okay. Curtiss-Wright was a corporation, and they were indicted for a crime of selling machine guns in the Chaco region. Okay. Now, I'll come back to Heidi because you started answering my next question correctly. Heidi, what law did Curtiss-Wright violate?
They violated the joint resolution that
What is a joint resolution?
something that Congress approved regarding the work. It doesn't really explain what it all.
Yeah, they don't explain what it is, right? So usually, right, Congress passes a statute. The statute says, if you sell machine guns or any kind of arms in Bolivia, you will be sentenced to 10 years in federal prison. Heidi, any problem with that kind of statute, right? No. But a joint resolution is something different. Congress does not actually pass a statute that says this activity is criminal. What they actually did, I think I have it up here somewhere. Here it is. Congress passed a joint resolution, right? Now, a joint resolution is not like a bill. It's not like an actual act, but it's still voted on by the majority of both houses of Congress. And what it said is this: resolved by the Senate and House of Representatives of the United States that if the president finds that the prohibition of the sale of arms and munitions in these countries makes due to establishment of peace, then he should. Okay? So in other words, if the president determines that it's a good idea to prohibit the sale of arms in the Chaco War, then it becomes a crime. Okay? What does the president do? He has to make a proclamation to that effect. And if the president makes a proclamation, it'll be illegal to sell weapons in this region. So basically, Congress was giving the president permission to criminalize the sale of arms in this region. And then FDR indeed said a proclamation. He said, I make applicable to Bolivia and Paraguay. I warn all violations. If you sell arms in this region, I will prosecute you. So Congress said if the president wants to, he can then make this proclamation, which will allow him to then go after these companies. Okay, Alexis, I'll come back to you. Alexis, do you see a problem with this in terms of things we've learned about so far? Do you see any separation of powers issue with this proclamation and this joint resolution? Are there any problems here? Yeah. What's this non-delegation doctrine? This keeps coming up. What's this non-delegation doctrine we've talked about? Why would this statute perhaps run afoul of the non-delegation doctrine? I think you already said it, but I want you to just say it one more time. What about this joint resolution may run afoul of the non-delegation doctrine?
They said that
I don't care what the court said. I'm asking you, looking at this resolution, what's problematic about it? Exactly right. You already said it. I want to just repeat it. What this resolution does is it gives the president the power to decide what a criminal law ought to be. The president, by making this proclamation, effectively establishes a new criminal law. By this resolution, the president effectively establishes a new criminal law. He can decide, okay, it's applicable to Bolivia and Paraguay. Did the joint resolution say anything about Bolivia or Paraguay? No. It's just at the Chaco region, right? So now the president has effectively expanded the scope of a federal criminal law. Ryan, what case does this make you think of that this is problematic? Well, I mean, there are a couple of cases you can think of, but what's problematic about this decision or this joint resolution?
I think they might have mentioned the.
It's not in the case. I'm thinking of a case that happened several decades later. What is problematic about Congress doing something in this manner?
I think it might be the Youngstown case.
Well, not just Youngstown. I think it's something very specific. What's Congress doing here? They're passing this resolution, right?
Yeah, they're delegating a power to.
And then what happens after they pass a resolution? What does the president then do? Is he signing it exactly as written?
No, I don't think so.
What's he doing?
He just has the power to decide if he wants.
And not do what Congress said. What does he have power to actually do?
Whether he wants to actually
Do something else, right? He can do something else. What do we call it when Congress passes a bill that says X and the president does something else? What case does that remind you of?
I think it was the line item.
Exactly. Line item veto, right? This is Clinton v. New York. Congress passes something and the president does something else. Didn't we say in Clinton v. New York that the president must do precisely what Congress enacts? He can't deviate? This is far worse than Clinton v. New York, because it wasn't the president simply deciding not to spend certain amounts of money. He was effectively creating new federal crimes by presidential proclamation. The president was created new federal crimes by presidential proclamation. And in fact, in this case, the lower court dismissed the indictment. They dismissed the charges. Why? They said, quote, "This is an attempt to substitute executive determination for legislative judgment. That the president was using his own judgment what ought to be a crime rather than following what Congress said." Congress basically gave the president a blank check to write a new federal criminal law. And the lower court invalidated the prosecution on this basis. Everyone understand that. This is not in the case, but this is actually the non-delegation doctrine, which we keep mentioning, popping up. Everyone with me so far? Okay. So, Travis, so we said before that the president has two sources of power, right? An act of Congress and the Constitution itself. Let's assume for the moment, right, that Congress cannot give this power by statute. How else could President Roosevelt's actions be justified then, if it's not from an act of Congress?
Through the Constitution.
And what constitutional power gives him the authority to do this?
Power vested in the president.
Yes. So with this case, and again, it's a very muddy case, and if you didn't really understand it reading it the first time, that's okay. This case isn't really about whether Congress can give the president the power to punish these companies selling arms overseas. This is effectively a case about executive power inherently. What are the inherent executive powers that the Constitution vests in the president? And I think if you read the case that way, it makes a lot more sense. If you read the case that way, it makes a lot more sense. By the way, these are the picture of the machine gun carrying Chaco War soldiers. These are actually Paraguayan, not Bolivian, but this was from the conflict. Okay.
One question.
Yes.
So if the statute said,
president cannot, and no company can sell any arms to neither.
Name the countries, right? Name the countries.
Yeah, or name the countries where it said no country, can receive goods being sold by American companies.
So let me ask you a question. That's John, right?
Yes.
John, let me ask you a question. Why do you think Congress would not pass that kind of statute?
Because it's way too specific.
Well, why is it too specific? What's the effect of such a statute?
Because they don't want to make a decision between which country that.
And that was actually my very next point. Mike, I'm sorry. You're exactly right. Congress did not want to interfere with the president's determinations. Because what happens if today we're supporting Bolivia, and then tomorrow we decide to support Paraguay? Congress did not want to interject itself and spell out with specificity which side of the conflict we're on. That's why the proclamation said Chaco region. It was deliberately vague. So that's the question, right? Did Congress want to interfere and specify exactly who was bound? In this case, Congress didn't. They wanted to leave it open for the president to decide. So the question becomes, does the president have this power to criminalize actions based on presidential proclamation? We say the executive power doesn't include the power to make laws. Here, FDR basically made a law. He made a federal criminal statute, which he prosecuted the Curtiss-Wright company on the basis of. So the court says, right, we don't need to determine if the joint resolution was an unlawful delegation. Right? They say that at the outset. We don't need to determine if this was an unlawful delegation. Why? Because we're not talking here about a matter of internal affairs. This is, quote, a remedy for a hurtful condition in a foreign territory. There's a difference between domestic law and foreign policy. And what this decision seems to stand for is the proposition that when the president's dealing with foreign affairs, he has this body of inherent power that's not enumerated that he can rely on to do stuff that he otherwise could not. That because this is a foreign affairs, the president has this authority. They won't get that much, right? This is not a case where you're questioning whether Congress can give this authority. The court says, we're not going to decide that because, frankly, this statute, this resolution is unconstitutional. Horribly so. So they say, okay, we can't do that, right? So let's find a different way of ruling. And let's say the president has this power over foreign affairs. And Justice Sutherland's opinion traces us through the history, which I shared and mentioned a couple minutes ago, about the colonies getting the power from English, and then the colonies, made a Continental Congress, and the Constitution got those powers. So whatever the executive power the king had, the court says, effectively transferred to the president. Roosevelt has the same powers as King George III. I'm sure he thought so. So we have this situation here where you have this inherent powers over foreign affairs. Now, that part of the decision is probably wrong, okay? And you'll see why when you read Zivotofsky next week. It wasn't, this issue is basically lingering for, I don't know, about 90 years. When you read Zivotofsky next week, you'll see why it was probably wrong. But let's discuss, Dan, why do you think it's a good idea for the executive to have some sort of broader, unchecked power over foreign affairs? Right? Why do you think it's a good idea?
Well, first, because the president is vested to be the country's diplomat. So it's very hard to, put that in a net, so to speak.
What does that entail, though, to being the country's diplomat? Why is that such a significant duty?
Because it affects our relationship with other nations.
Exactly right. So consider the Constitution, right? Look, go through the powers. This is in Article 2. The president has the power to make treaties, right? The Senate votes to ratify them. But the Senate is not involved in negotiating the treaties, right? Taylor, why do you think the Constitution does not give a role to the Senate to negotiate the treaties at the outset?
Because that would hamstring the ability.
Exactly. So, I mean, now we have 100 senators, or we have like 20-something senators, right? Imagine having 20-something people with different interests from different states trying to negotiate over the same provisions of a treaty. You'll never get anything done. Having the one president with his Secretary of State make this a determination that makes it easier. Similarly, the president gets to appoint ambassadors, right? The president gets to receive ambassadors. This is something that probably never thought much, you probably never thought of, right? But let's say there's a new country that emerges. Let's call it South Sudan. I don't know, whatever the country is, right? A new country emerges. Lara, what makes a country? What is a country? You never thought of this question before. What does it mean for something to be a country? Like, can I plant a flag in my backyard and say this is the land of Josh? I mean, is that a country? Can I,
for other countries to recognize.
Exactly. In international law, you only become a country when others recognize you as such. You only become a country when others recognize you as such. I can plant a flag in my backyard, and if no one recognizes it, then I have no country. The power to appoint ambassadors and to receive ambassadors, as you'll see next week, is part of what's called the recognition power. Right? If the president of the United States decides to send an ambassador to South Sudan, that's an act that South Sudan is a real country. If the president of the United States welcomes an ambassador, right? He receives an ambassador from South Sudan. He gives him credentials to have a diplomat and a station in the United States. That means South Sudan is a real country. So the act of recognizing, appointing, and receiving ambassadors is a very significant attribute of foreign affairs powers. So the Constitution gives the president significant leeway over foreign affairs, right? And we've said, why does it make sense to have one president doing this rather than having, the 30 members of Congress, however many there were, do it? Well, one person can make a decision and have a consistent foreign policy, right? They treat all the countries equally, and you want these very sectional conflicts. So what the court says then is that Congress's role in foreign affairs is limited. And the next phrase I'm going to read to you is a law student's favorite phrase, which is almost certainly wrong. I'm going to read to you anyway. The court quotes John Marshall, the great John Marshall from 1800, before he was even in the Supreme Court. He was still in the House of Representatives. John Marshall wrote, and you will all quote this in your exam dutifully, it's wrong, but John Marshall wrote, "The president is the sole organ of the nation in its external relations." The president is the sole organ of the nation in its external relations. Okay? What does this mean? What does this mean? Robin, what does this mean?
That he is
What's his sole organ business?
the chief or the principal body that's going to go out and do things like negotiate treaties. He's going to represent our country.
Yeah. So if you read Curtiss-Wright, right, you would think that the president has unlimited powers over foreign affairs. So this phrase, the sole organ, was treated as gospel for almost 80 years. As you'll see next week in Zivotofsky, the court calls this a dictum. If any of you have done the reading yet. The court calls this sole organ line a dictum. I mean, we all knew this was a dictum, but the court actually recognized it in the Zivotofsky case, which you'll read next week. But let's discuss it for what it is. The reason why this is a dictum is because it's almost certainly wrong. Because even though the president has the power to negotiate the treaty in the first instance, unless the Senate ratifies it, the treaty is worthless. Even though the president has the power to nominate an ambassador to some new country, right? Unless the Senate confirms it, the ambassador goes nowhere. So there's a check, and there's a significant check on the president's power over foreign affairs. So that's why I say the sole organ line was always wrong. And like a year ago, whenever it was Zivotofsky, the court said it's a dictum. But at its time, though, Curtiss-Wright represented a very significant expansion of the reading of the executive's powers. Okay. One other note that I want to stress, the court makes a big deal of the fact that the president and Congress were on the same page, right? Katie, this is before Youngstown, but what do we do when the president and Congress, tend to agree on how to share their power? How to, under the Jackson approach, how should courts view this?
They said that was a big thing, that it's like a clear, it wasn't like the Twilight Zone.
Exactly. What Jackson said, again, Youngstown came much later, but what Jackson said, when the president and agree how to share their powers, the court should not be, skeptical. They should defer. Of course, if you look at what Scalia said and what others have said, separation of powers don't matter if they agree. It doesn't matter if they agree. The separation of powers ought to be held for their own sake. But here, this is a very wishy-washy, flexible opinion. One last point. The court said that this kind of resolution has been going on for a very long time. And because of past practice, who are we to second guess? So, you're seeing themes now in executive powers cases, right? They look to past practice. If this has been done for a long time, courts shouldn't second guess it. The courts often look to if the parties agree. If Congress agrees and the president agrees, we ought not second guess it. Okay? These are themes of past practice and what's called acquiescence, right? That repeat in all these cases. So in a very unsatisfying opinion, which is very hard to reduce to a holding, the court affirms the convictions, or the court basically allows the trial to proceed against Curtiss-Wright, finding that effectively the president is a sole organ of a foreign policy and he has the inherent power to prosecute these individuals, even though there's no statutory authority to do so. This is a very broad decision, and it's almost certainly wrong. And for decades, law professors said this has to be wrong. And finally, in Zivotofsky, the Supreme Court acknowledged it. But what I'd like to stress is that, again, this was a decision during a time of war. There was a conflict abroad. And the court did not want to be in the position of second-guessing the president's ability to manage foreign relations during this very difficult time where there was a war in our hemisphere. Okay. Everyone get Curtiss-Wright. Any questions on Curtiss-Wright? It's a hard case, and the only sentence people ever remember, and every year I read the exams and I hate it, the president's the sole organ of foreign affairs. I don't want you to simply parrot that. And in fact, if you use a commercial outline that was written before Zivotofsky, that's exactly what you're going to write. I can tell. So there's been a change, right? So it's not merely the president as a sole organ, as we see here. There's checks on the president's powers. It's a shared authority. But this case does recognize the president has inherent powers over foreign policy. Okay? Okay. Any questions on Curtiss-Wright? Okay, let's move on. Next case, Dames and Moore v. Regan. And again, it's not Reagan. This is not President Reagan. It's Don Regan. Don Regan was Reagan's Secretary of the Treasury, to make it even more complicated for you, but it's not Reagan. So the facts of this case are actually really interesting because Iran seems to always be in the news, no matter what decade we're in, at least the last 40 years or so. And again, this is sorry, not Don Regan, Tom Regan. Tom Regan was the Secretary of the Treasury in the Reagan Justice Department, and this is the logo of Dames and Moore. So, who am I up to? Is that Sarah? Okay, Sarah, tell me what were the facts here? What happened that led to this case? I'm sorry, I can't hear you.
So there was a seizure for the American personnel.
Where?
Iran.
Yeah, the American Embassy, right? Exactly. Good. What happened at the end? What happened after the? What happens after the Iranians seized and took hostage the people working at the American Embassy in Tehran?
They suspended all teams in which.
Oh, there's lots of happened between that. Let's go more incrementally, right? So in 1979, the American Embassy in Tehran was basically captured by the Iranians, loyal to the Ayatollah. If you ever seen the movie Argo, right? Argo explains what happened and it discusses an attempt to exfiltrate or help break out a number of people at the embassy. Okay, the hostages were released on January 20th, 1981. Does anyone know the significance of the date of January 20th? It's a very significant date.
Regan was being framed.
It was the inauguration of the next president, right? It's one of the few dates in the Constitution that was the big one for me. All right, so January 20th is a day of the Constitution. Did I explain this, that the president took the oath 4 times, Obama? Did I tell you this part? Yeah, that's why he had to take on January 20th, which was a Sunday. So on January 20th, the day President Reagan was inaugurated, the hostages were released. Now, the part that people don't like reminding is the negotiation was actually reached by President Carter the day before. So the day before, President Jimmy Carter and his administration reached an agreement for the release of the hostages from the embassy. But part of this negotiation was an attempt to settle all pending litigation between the United States and Iran. I'll come back to you, Sarah. Sarah, why do you think, as part of the release of these hostages, the United States wanted to settle all the pending litigation? Why do you think that was, why do you think that was done?
Well, to not stay on that note.
I'm sorry?
To not stay on that note.
Yeah, very good. Effectively, they said, listen, we have this really bad situation with these hostages. Let's try to start from scratch. We don't want to have all these pending claims floating around because that can complicate our relations. So, Ashley, what did Ashley V? What did the executive agreement which Carter issued and then Reagan agreed to as well? What did this executive agreement provide with respect to these pending cases?
And to suspend all the
Good. What does that mean, suspend pending cases?
so basically end them.
Yeah. Think about that, right? You guys are going to be lawyers in a couple of years. Imagine if you'd sued the Iranian government, like say you had a contract with the Iranian bank or whatever, right? You had a pending case. It was pending in court. You were awaiting a trial. And this executive order just said case dismissed. Right? Case dismissed. But they didn't just suspend pending claims. Right? Ashley C. What else did this executive order do? It wasn't just about pending claims. What else did they do? Yeah. Yeah, Ashley, may I ask you the question like this. What happens if your case had already gone to a trial and the jury said, we award Ashley $5 million, and then you're trying to collect the money, right? What would happen to that judgment to collect? Could you now collect it under this new executive order? Hey, louder, I can't hear it. You could or could not? No. What does it mean to suspend the judgments? What does that actually mean, Ashley? Exactly. So the executive orders had 2 effects, right? First, they suspend all the pending cases. If you had a pending case against an Iranian government official or Iranian company, whatever, case dismissed. What if you already had a judgment that was pending, right? You were trying to collect in your judgment? Nullified. You were required to go to what's called this Iran-U.S. Claims Tribunal, where basically you submit your claim to this tribunal and hopefully you get paid. You probably won't, right? But hopefully there's this big chunk of money being held in the Bank of England, and then you could try to get your judgment from this fund. But you could no longer use the United States federal courts to retrieve, or the state courts for that matter, to retrieve the funds which you're due. Now, Luis S. Luis S., what's problematic about the president issuing an executive order to suspend claims and to terminate all of your judgments? What's problematic about that? Yeah, so let me ask you a question. Right? What case does this remind you of? About seizing property. What does this remind you of? Yeah, Youngstown. Why is this like Youngstown? Yeah. Right. There's not, I mean, it's a complicated distinction, but they're basically the same case. In Youngstown, President Truman said, listen, we're going to take your We're going to take your steel mills and put them under federal supervision. Maybe we'll pay you for it later. Maybe we won't. I don't care. Here, President saying, listen, we're going to take your federal pending lawsuits and we're going to dump them into this tribunal. Maybe you'll get paid. Maybe you won't. We don't know. But the greater good of national security and having peaceful relations with Iran, yeah, that worked well, right? Having nice, peaceful relations with Iran, everything will be awesome after this. We settled. So then Luis B., what then was the problem in Youngstown, right? Why did the president lose in Youngstown?
Because Congress was not in accordance with the president's view.
Yes. So in Youngstown, the court held that the president did not give, that Congress did not give the president authority to seize the steel mills, right? Right, Luis? So the question here is what? How does the government win this case? What did they have to show, Luis?
They have to show that Congress was not against the president.
Yes. What this case is about is showing that Congress provided the president with the authority to seize and terminate these lawsuits. Everyone get that, right? The question in this case is basically Youngstown's sequel. In many respects, it is a sequel to Youngstown. Does the president have the power to seize these lawsuits and seize these judgments and terminate them in federal court? I mean, this is a very big deal for the president to terminate a lawsuit. I mean, this is a really significant power. Congress, I don't even know if Congress could do this by itself. By the way, I think this case was wrongly decided, but we'll explain why in a few minutes, right? But this is a very interesting sequel to Youngstown. So one point that I'd like to address, and this is actually a fascinating historical oddity. So we all know that the concurring opinion in Youngstown by Justice Jackson over here. And Justice Jackson's opinion is considered, the definitive statement. But what's interesting is, do you know who was clerking? Maybe you watched the video last night, so don't raise your hand. Who was clerking for Justice Jackson the year Youngstown was decided? A young Stanford graduate by the name of William Rehnquist. William Rehnquist was clerking for Justice Jackson the year Youngstown was decided. What's even funnier is that Rehnquist hated the opinion. Rehnquist said this opinion's wrong, and it doesn't defer to the president enough. Rehnquist would have dissented. He was a law clerk, right? So Rehnquist was written by Jackson himself. The law clerks didn't help him with this. And Jackson's law clerks disagreed with the decision. In fact, Rehnquist wrote a memo to Jackson like, your opinion's wrong. Can you imagine, right? You're some young idiot law clerk, a couple years out of law school. Rehnquist was an idiot, but you're some young brash law clerk, a few years out of law school. By the way, Rehnquist graduated first in his class at Stanford. No, graduated second in his class. Sandra Day O'Connor. They were classmates. They even dated briefly, but they were classmates. And he graduated one, she graduated two. He got a job as a lawyer. She got offers to be a secretary. It was actually a very difficult time. Lawyers, as females, weren't hired yet, but she made it through. But Rehnquist, this young brash lawyer, refused to, support Jackson's opinion. Anyway, but Jackson wrote the opinion, and the rest is history. So now, we fast forward to Dames and Moore v. Regan, 1981. William Rehnquist wrote the majority opinion in 8 days, in the span of 8 days, in many respects, building on and I'll say modifying Jackson's opinion. Do you know who was Rehnquist's law clerk in 1981? John G. Roberts, the current Chief Justice of the United States. I find this so fascinating. Every time I teach it, I get the chills, right? So, you have basically Jackson clerking, Rehnquist clerking for Jackson, for Youngstown. And then 30-something years later, you have Rehnquist is now the Justice of the United States, and you have John G. Roberts clerking for Rehnquist. And then, as you'll see in Zivotofsky, the Chief Justice dissents, citing all the people before him. It's this kind of stuff you can't really make up. But you have this chain of events, which I find fascinating. Interestingly enough, I've actually looked up the other two clerks for Rehnquist. I mean, they're lawyers, but nothing. They're not the chief justice. So where are they now? I mean, one was like a lawyer in Florida, to personal injury. Like it was whatever. The guy, the short one's the chief justice. I guess those glasses are back in style now. I suppose I don't know. So I actually only got glasses. This is the first semester I've had glasses. I just got them a month ago. I'm still not. That's why I keep taking them on and off. I don't know how to wear them. It's very confusing because I can see close fine, but I can't. Distance is fine, but I can't see close. I'm looking at my screen and looking at you. I have to keep going back and forth. I haven't quite figured it out yet. So we have then this case, right? And we have the Dames and Moore Company. So they had. You can imagine. There was a time when Iran was an ally of ours. Under the Shah of Iran, Iran was an ally. So an American company, can you imagine, had an arrangement with Iran to build a nuclear power plant for them, right? Can you imagine the entire nuclear, whatever deal we have now? In the 70s and 80s, Iran actually made a deal with an American company to develop a nuclear power site. Unsurprisingly, after the Iranian Revolution and the seizure of the hostages, the Iranian government suspended the contract, unsurprisingly. And as a result of the suspension of contract, there was a breach. And Iran was supposed to pay to Dames and Moore $3.5 million. The district court basically entered summary judgment against them. And then what happened? Dames and Moore went to a court in Washington and said, hey, these people have property in the state. I want you to attach the property to collect my judgment. You know what this means? The number one rule of being a lawyer. Anyone, what's the number one rule of being a lawyer? Number one rule. What? No, not Rule 11, before Rule 11. The number one rule of being a lawyer, get paid. Get paid. Because if your client doesn't pay you, you can't keep the lights on. I'm serious. If nothing else, get paid. That's all you have. I mean, that's if you don't get paid, you're not going to be a lawyer very long. So here, the lawyers wanted to get paid. And the way they were going to get paid was by seizing property in Washington, where the Iranian government had a property. So they said to the court, hey, they owe us $3 million. Go put their land up for auction so we can get some money out of it, right? Because the Iranians weren't writing a check. So after they made this judgment, the president issued this executive order, which suspended all the claims, and so they now have to deposit any of their claims into this tribunal. So then Dames and Moore sued the United States government. And this case went very quick. I think the case was filed in April of 1981. It was argued in June of 1981 by the Supreme Court and decided 8 days later. So basically in the span of like 5 or 6 months, the entire case went top to bottom, which is remarkably fast. But like Youngstown, when you have these separation of powers disputes that affect foreign relations, the justices can kick into high gear. They can move fast. Okay. So everyone with me so far. So again, let's talk about junks. Yeah. Oh, is Rebecca not back yet? I was going to call on her. She's still not back. Fine. I'll get back to her later. That's Catherine 1, right? Catherine E. Catherine. So remind me, what are the 3 tiers of Jackson? Right? What are these 3 tiers of junks? How we discussed before?
So you've got the first tier where Congress and President are in conjunction with each other, and so the judicial branch should just kind of let the lead.
Good.
Then you've got Twilight, where
Good.
And then you've got the third, which is where they're not in conjunction.
Very good. Very good. Okay. So the question for the court here today, and I'm reminding you, William Rehnquist did not like these 3 tiers. As a law clerk, he wrote that they were stupid and we should defer to the president, which is exactly what they do here. So the dirty little secret is Youngstown is modified by Dames and Moore. Rehnquist tweaks. He tweaks the zone of Twilight. He tweaks it. And I'll explain what I mean. So let's talk about the 2 claims separately, right? The first claim is about suspension. The second one is about the judgments. And let's talk about them separately, right? So Catherine D, does the court find that the president has the power to suspend claims in court? Is there a doubt about whether he can suspend claims?
I think at first, if you look at the
Okay, what are these acts?
Acts that they were enacted, kind of inadvertently.
Mm-hmm. Good. So what we have here, right? And I like the way Catherine explained it. There is no one single statute that Congress passed, right? Congress did not pass a statute saying the president can seize these claims and then the president can terminate these judgments and put them into the tribunal, right? You have these statutes that are in the general ballpark. You have these things like my favorite, IEPA, right? IEPA, the International Emergency Economic Powers Act, and the Hostage Act. These acts don't specifically say that the president has the power to terminate these settlements in Iran. However, these acts do show that Congress is comfortable with the idea of the president suspending claims in court. Everyone see the difference? There's nothing clearly saying that Congress wants the president to do this, but they allowed similar actions in other contexts, so Congress is comfortable with this. They're comfortable with this. Everyone understand that?
I have a question.
Yeah.
So this falls into
Well, you tell me, where does it fall? That was my next question, yeah.
constitutionality by practice, right?
Good.
So, but it still doesn't answer the question if the president actually has that power. Because
Yes.
it's sort of given this inference of,
Yes. And that's exactly right, Dan. That's exactly right. What Rehnquist writes is that both statutes are, quote, highly relevant in the looser sense of indicating congressional acceptance. They're highly relevant in the looser sense of indicating congressional acceptance. So this is not a case where there's a direct delegation of authority. All these statutes say is that Congress is comfortable with this sort of thing, even if they haven't done it in this case. This is, as Dan mentioned a moment ago, about past practice, right? What has Congress done before? What are they comfortable with? And can we, relate that to what's going on here? Can we connect what Congress has done before to what's going on here? Is there a long-standing practice of the executive settling claims by this manner? Yeah. Did Congress specify they can do it here? No. And for that, the court is enough. Rehnquist writes, Congress, quote, implicitly approved of this. They implicitly approved of this. It was implicit. It wasn't explicit. It was implicit. So, Jacob, where does this put us with Justice Jackson? Right? Where do we find ourselves with Youngstown? How do we square this together?
It seems like he's objecting it's very dependent on the situation. It's like the president had, and especially in cases with hostile acts by foreign nations, that the president should be more benefit of doubt.
Okay. So what Rehnquist is basically saying here, right, and this is why I say he didn't like Jackson 30 years earlier and he doesn't like him now, is he effectively modifies what Zone 1 means. Right? I think Catherine said this a minute ago. We understood Zone 1 to mean where the president and Congress are on the same page, right? Where Congress gave the president the authority he needed. Rehnquist tweaks that, and he says it's not necessary for Congress to give the exact or the precise authority. It's not necessary for the president to give Congress the precise authority. It's sufficient for Congress to accept the general practice. It's sufficient for Congress to be generally okay with what happened. That's enough. And he writes, if there's some sort of practice that goes back a long way and Congress never seems to object, that's good enough to get us into Youngstown Zone 1. He doesn't say that exactly, but I think that's the best way of reading it. Catherine? I'm sorry, Congress acquiescing. What was the second one?
And not objecting to
Ah. So there's two ways, right, to look at this one, right? First way is, if over the last 30 years, in every instance, the president's done something and Congress hasn't objected. That's a long-standing practice, right? That's acquiescence. But here, Catherine, let me ask you this question. What would have happened after the president sees the bank statements? If Congress called a hearing and said, wait a minute, this is wrong. And Congress passed a bill saying, no, President, you can't do this. You can't seize these assets. Well, how would we understand that post-enactment action?
So you would say that they did not.
They didn't object. And Rehnquist says at the very end of his opinion, right? He says it's relevant that Congress has not disapproved of the actions taken here. He says, quote, no legislation has indicated displeasure with this agreement. So even after the president did it, Congress was silent, just like in Youngstown. Remember? In Youngstown, Congress was silent afterwards. And the court said that's irrelevant. So in many respects, Rehnquist shapes Youngstown again. I'll give you a preview of the reading for next week in the immigration case. So for example, after President Obama took executive action on immigration in November 2014, the following month, the House of Representatives passed a bill saying this is illegal. They passed a bill saying this is unconstitutional. That bill didn't go anywhere because the Senate filibustered it. But you have a House of Congress affirmatively saying, you took this action, we disagree. And I think, I've argued elsewhere that this is actually very relevant to the question of whether, in fact, Congress is acquiescing and Congress is given in. So Rehnquist closes and says, look, we're definitely not in zone 3. This is not a situation where Congress has resisted the authority. He doesn't really say if we're in 1 or 2, but if my reading of the case, which is one that probably matters more to you, is that he's basically tweaked zone 1 such that it's not now required to have an explicit delegation. That a general acceptance, he's okay with it, is significant. Okay. Questions on Dames and Moore? Questions on Dames and Moore? Anything? No questions, Dames and Moore? Okay. Yeah, sure.
I guess I thought earlier that you said he essentially tweaked his own twilight.
Yeah, I think under Jackson's original framework, this is probably a zone 2 case, which would require the courts to be somewhat skeptical. But what what Rehnquist basically did was he expanded zone 1 a lot, and he pushed this case into the first tier. And because it's in the first tier, the courts will not second guess what Congress did and what the executive did. Yeah, I mean, my own opinion, which what's not worth much, but this is probably a case where, honestly, I think this is a zone 3 case. Congress did not give the authority, but I can even be charitable and say maybe it's unclear if Congress wanted to or not. It's definitely not one. Yes, Zachary?
Okay, so this is a hypothetical question.
Sure.
But, say that the decision on this case was different and they did allow the settlement to go through, or like any other situation, could the Supreme Court essentially be declaring war? Like, not that's taking a little too far.
I see what you're getting at.
Yeah, they make so many decisions where it's against the.
Okay, a very good point. So Zach's question is this: what happens? The president had spent 1.5 years negotiating for the release of our hostages, and one of the essential elements of that deal was that you suspend all these lawsuits. And then the Supreme Court comes and says, "Oh, just kidding, guys, you can't do that. You can't do that." And then Iran says, "Okay, screw this, peace of court's out. We're going to start a war." Could the court have meaningfully ruled against the president here? Could the court have then been responsible for a new embassy in Iran to be burned down? This is a serious case. This is why it was resolved in 9 days, because they had to get this out quick, right? You don't want the Iranian government to be skittish and back out of their deal. There was another case mentioned in your readings called Medellin versus Texas, which is a very, very interesting case. Interestingly enough, it was argued by a guy named Ted Cruz, who used to be our Solicitor General here in Texas. He was a brilliant advocate, a very, very one of the top Supreme Court lawyers we had. And the facts of the case were like this. You had a guy, Medellin, who raped and murdered 2 teenage girls in Texas. He was a Mexican national. He was not a U.S. citizen. He was tried and convicted of murder. Now, the United States has been part of a treaty, and the treaty basically says if any foreign nationals are convicted of or accused of crimes, they're required to speak with a consulate from the home country. So Medellin would have had to have access to a Mexican consulate before he was tried, whatever. An international court, and by the way, these are not real courts. There's no such thing as international court. They have no jurisdiction. They're just groups of people in robes. But an international court said to America, let Mr. Medellin go because he didn't talk to a consulate. Okay, they have no authority to say anything, right? But President Bush, who ironically enough was the governor when Medellin was convicted, President Bush issued an executive order telling all 50 states to suspend any convictions against defendants who are not given their consular rights. So imagine that President Bush, former governor of Texas, said, hey, Texas, let this, not let him go, but don't execute him. Give him another trial. Texas said no, right? But the reason why, and this is actually one of Ted Cruz's smarter arguments, is that the president lacked the authority to suspend the criminal conviction of Medellin. That the president lacked the authority to suspend it. And whereas in Dames and Moore, Rehnquist was able to grasp for these statutes that kind of gave the authority, in Medellin, Cruz argued for Texas, listen, this treaty, which says you give consular rights, was ratified, but Congress never enacted any legislation to implement it, right? Congress never passed a statute to implement the statute, this treaty. Therefore, there was no authority given to the president, and the president lacks the inherent power to suspend claims by himself. So in that respect, it was like a worthy sequel to Dames and Moore. And the court basically held that the president does not have the power to tell a state to suspend an execution. And Medellin was executed, in case you're curious. But this wasn't even 9-0. I think this was was again addressed by both Justices Breyer and Scalia about whether this sort of thing can happen again. Breyer said, no, it'll never happen again. Scalia said, don't kid yourself, folks. And the issue here has to do with, in the time of World War II, what can be done under the president's commander-in-chief power. So I'd like to show you a video. I'll come back to the case in a minute, but I want to show you this video first. This is a piece of American propaganda. There's no other way of explaining it. It's American propaganda. And the purpose of this video is to demonstrate what the United States government was telling the American people about the Japanese internment during the war. So it's like a 9-minute video. You're gonna watch the entire thing. I usually don't do videos, but this one's actually worth it. So just take a minute to watch this, okay? And again, this is actually real. This is not part of it. Eisenhower, like his son or something.
When the Japanese attacked Pearl Harbor, our west coast became a potential combat zone. Living in that zone were more than 100,000 persons of Japanese ancestry, 2/3 of them American citizens, 1/3 aliens. We knew that some among them were potentially dangerous, but no one knew what would happen among this concentrated population if Japanese forces should try to invade our shores. Military authorities therefore determined that all of them, citizens and aliens alike, would have to move. This picture tells how the mass migration was accomplished. Neither the Army nor the War Relocation Authority relished the idea of taking men, women, and children from their homes, their shops, and their farms. So the military and civilian agencies alike determined to do the job as a democracy should, with real consideration for the people involved. First attention was given to the problems of sabotage and espionage. Now, here at San Francisco, for example, convoys were being made up within sight of possible Axis agents. There were more Japanese in Los Angeles than in any other area. In nearby San Pedro, houses and hotels occupied almost exclusively by Japanese were within a stone's throw of a naval airbase, shipyards, oil wells. Japanese fishermen had every opportunity to watch the movement of our ships. Japanese farmers were living close to vital aircraft plants. So as a first step, all Japanese were required to move from critical areas such as these. But of course, this limited evacuation was a solution to only part of the problem. The larger problem, the uncertainty of what would happen among these people in case of a Japanese invasion, still remained. That is why the commanding general of the Western Defense Command determined that all Japanese within the coastal areas should move inland. Immediately, the Army began mapping evacuation areas and for a time encouraged the Japanese to leave voluntarily. The trouble for the voluntary evacuees soon threatened in their new locations. So the program was quickly put on a planned and protected basis. Thereafter, the American citizen Japanese and Japanese aliens made plans in accordance with orders. Notices were posted. All persons of Japanese descent were required to register. They gathered in their own churches and schools, and the Japanese themselves cheerfully handled the enormous paperwork involved in the migration.
Cheerfully, right?
Civilian physicians made preliminary medical examinations. Government agencies helped in 100 ways. They helped the evacuees find tenants for their farms.
They had to sell their businesses.
They helped businessmen lease, sell, or store their property. Now, this aid was financed by the government, but quick disposal of property often involved financial sacrifice for the evacuees. Now the actual migration got underway. The Army provided fleets of vans to transport household belongings and buses to move the people to assembly centers. The evacuees cooperated wholeheartedly. The many loyal among them felt that this was a sacrifice they could make in behalf of America's war effort. In small towns as well as large, up and down the coast, the moving continued. Behind them, they left shops and homes they had occupied for many years. Their fishing fleets were impounded and left under guard. Now they were taken to racetracks and fairgrounds where the Army almost overnight had built assembly centers. They lived here until new pioneer communities could be completed on federally owned lands in the interior. Santa Anita Racetrack, for example, suddenly became a community of about 17,000 persons. The Army provided housing and plenty of healthful, nourishing food for all. The residents of the new community set about developing a way of life as nearly normal as possible. They held church services, Protestant, Catholic, and Buddhist. They issued their own newspaper, organized nursery schools, and some made camouflage nets for the United States Army. Meanwhile, in Arizona, Utah, Colorado, Wyoming, and elsewhere, quarters were being built where they would have an opportunity to work and more space in which to live. When word came that these new homes were ready, the final movement began. At each relocation center, evacuees were met by an advance contingent of Japanese who had arrived some days earlier and who now acted as guides. Naturally, the newcomers looked about with some curiosity. They were in a new area, on land that was raw, untamed, but full of opportunity. Here they would build schools, educate their children, reclaim the desert. Their own physicians took precautions to guard against epidemics. They opened advanced Americanization classes for college students, who in turn would instruct other groups. They made a rough beginning at self-government, for while the Army would guard the outer limits of each area, community life and security within were largely up to the Japanese themselves. They immediately saw the need for developing civic leaders. At weekly community meetings, citations were given to the block leaders who had worked most diligently. Special emphasis was put on the health and care of these American children of Japanese descent. Their parents, most of whom are American citizens, and their grandparents, who are aliens, immediately wanted to go to work. At Manzanar, they built a lath house and began rooting guayuli cuttings. The plants, when mature, will add to our rubber supply. At Parker, they undertook the irrigation of fertile desert lands. Meanwhile, in areas away from the coast and under appropriate safeguards, many were permitted to enter private employment, particularly to work in sugar beet fields where labor was badly needed. Now, this brief picture is actually the prologue to a story that is yet to be told. The full story will begin to unfold when the raw lands of the desert turn green, when all adult hands are at productive work on public lands or in private employment. It will be fully told only when circumstances permit the loyal American citizens once again to enjoy the freedom we in this country cherish, and when the disloyal, we hope, have left this country for good. In the meantime, we are setting a standard for the rest of the world in the treatment of people who may have loyalties to an enemy nation. We are protecting ourselves without violating the principles of Christian decency. We won't change this fundamental decency no matter what our enemies do. But of course, we hope most earnestly that our example will influence the Axis powers in their treatment of Americans who fall into their hands.
So this was, again, an actual. You can watch after class. This was an actual video released by the United States government in the 1940s to explain what was going on. And I spend 9 minutes of class time on this quite deliberately because I want to convey to you how the American people were to understand what was going on. The bit at the very end, which most people started laughing at, where they said, we want to set a standard for the world. This wasn't just propaganda for Americans. This was meant to be sent abroad, because at the very time, American prisoners of war were being captured on the front in Germany and elsewhere. Not to mention that there were concentration camps where millions of Jews and others were being exterminated. So this was actually a sincere effort to say, hey, we can detain people without killing them, right? we can detain our people without loading them up to gas chambers. So there was actually ulterior motives here. But the video itself is strikingly honest in what it portrayed. I mean, the music and the narrations were absurd, but the videos were actually portraying what was going on these camps. So let me show you a bunch of pictures first. This is Fred Korematsu, who was the lead defendant. This is Korematsu a number of years later in his life. He died in the late 90s. I know Clinton gave him a medal. He died, fairly recently. He lived a long life. You saw this poster in the video, and if you can't read it, it says the Western Defense Command and 4th Army Wartime Civil Control Administration of San Francisco, May 23rd, 1942. This was roughly 6 months after Pearl Harbor. May 23rd, 1942. Instructions to all persons of Japanese ancestry living in the following areas, and they list, all this stuff. And I know you can't read this, but it says, pursuant to the provisions of the Civil Exclusion Order number 96, no Japanese person will be permitted to move into or outside this area after a certain date. Okay. This is what's called the exclusion order. There were actually 3 separate issues with a Japanese detention case. I want to separate them very clearly. There were 3 separate issues. The first issue was a curfew. The first issue was a curfew. This effectively said that the Japanese people of Japanese descent could not leave their homes, was it between 8 p.m. and 6 a.m., whatever it was. The times are not so important. That was the case of Hirabayashi. Here, let me write these out because they do get confusing after a while, which was which. So the first case was Hirabayashi. And this was about curfews. So the first case was Hirabayashi involving curfews. The second case, Korematsu, one I had you read, was about exclusion. And we'll discuss this more in a minute. But what Korematsu concerned was whether this order, this poster I showed you a moment ago, saying that all people of Japanese ancestry must leave a certain area, basically move away from the coast, whether that was constitutional. The third case, called ex parte endo, that was about detainment in the camps. Okay. The actual case about whether the government could lock these people up in a concentration camp, that was not Korematsu, that was endo. Most people always get these confused. Most people don't even know what endo is. Endo is actually the most important of the 3. Because in endo, to spoil the surprise, the court held that they could not detain people. So the court upheld the curfew, the court upheld the exclusion, but they invalidated the detention. Everyone with me? So you're saying, wait, what the hell is the point, Josh? If they can't detain them, where are they going to go, right? They get excluded to nowhere. So the dirty secret is by the time the court ruled on this issue, by the time the court ruled on Korematsu in 1944, this had already been going on for nearly 2 years. And FDR had basically told internally that I'm going to end this program. So by the time the court ruled in endo that they couldn't detain them, Roosevelt basically said we're going to shut down the camps. So the entire thing was basically for. However, Korematsu, which upheld the exclusion, was the Supreme Court's blessing of the policy. Had they just waited another month or 2, the case would have gone away. Okay, so let's actually walk through more of it. So we have the exclusion order. Let me show you some more pictures. The pictures are very powerful. And you can actually read the text of the order later if you're so inclined. I have another video, which I don't have time to show you. If you have time, you can watch this video also. It's about the same level. This map represents the different areas. So you see there's this thick line over here. That was considered the Western Front. And they basically decided that you can't have people of Japanese ancestry living in this Western Front. So if you were in any of these areas, you were to triangle, you have to control these relocation centers. Okay? And then after that, you have isolation centers, these little squares throughout. If you notice, they're scattered about. There actually were a bunch in Texas as well. They actually had a couple in Virginia. They're all over the place. One note, there were also people in the United States of German ancestry and of Italian ancestry, and they were not subject to any sort of removal. This may be something that people don't think much about today, but the prejudice against Asians in the western part of the country throughout the latter half of the 1800s and the early 1900s was very strong. There was a strong sense that the Asians were coming to steal jobs, and that they weren't assimilating, and that they had their own culture, and they cannot be made part of this country. You'll read a couple cases later when we do Plessy versus Ferguson and otherwise, where we'll read about this. But to give you an example, this was the headline of the San Francisco Examiner, and it says, "Ouster of all Japs in California near." Like, giddy, we can't wait, right? It's not like, oh my God, they're doing this. Like, oh, this is coming soon. And on the West Coast were, frankly, okay with this classification on the basis of race. So here are some pictures of these so-called camps or assembly centers where they were detained, and that's a picture of one of the barracks. The video in the video you watched made everything look a little bit nicer. This was more of a grisly picture of how it actually appeared. And they effectively built these camps overnight, these shanty towns in the middle of the wilderness. This picture wasn't in the video, but it shows the Japanese peering through barbed wire fences. And if this brings to mind images of concentration camps in Germany, well, it ought to. Here they are waiting in line, unclear what they're waiting in line for. Here they are being rounded up by buses and being basically told to bring, 2 satchels of your belongings to be thrown into a bus. This is a picture actually that people are uncomfortable with. That's Eleanor Roosevelt. So he wants to buy some chutzpah. So when Donald Trump went on the air saying that President Roosevelt, did this so I can exclude Muslims, the Roosevelt's daughter, who's like 90 now, I don't know how old she is, she had some statement saying, my mother was a fierce champion for civil rights, and even though my father did this, my mother opposed internment. Yes. So actually I did some research, right? And apparently Eleanor Roosevelt wrote this essay. It was a propaganda essay, I think in the Atlantic or some similar journal, saying how this was necessary and how they're treating them humanely. And to support the essay, Eleanor Roosevelt went to one of these camps and was photographed with all these propaganda shots with all these smiling internment prisoners. So with respect to the Roosevelts, you're not on Mount Rushmore quite yet. So Eleanor hears all these people smiling. Can you imagine staging this shot? I mean, honestly, right? Because, all right, everyone, smile. Okay, smile, First Lady's here. Here's a picture of Fred Korematsu, Minoru Yasui, who's one of the other plaintiffs or defendants, and the guy in the end is Hirabayashi. This is a cool picture. I like this one. Korematsu and Rosa Parks, representing. And here's actually a letter. Congress eventually voted for reparations for the people who were interned in these camps. And here's Fred Korematsu posing with this check. It wasn't a significant amount. It was like a few $1,000s, right? But it was something that they had. Oh yeah, and Clinton gave Korematsu the Presidential Medal of Freedom in 1998. Oh, that's right. He died recently. It was in 2005. He passed away. So actually, and this is a picture of Hirabayashi. This was the curfew case. And this is Mitsui Endo, she was the detention case. So let's walk through this decision. And I'll ask you to do something you probably don't want to do, right? I do have it every year. it's so easy to dump on this case. Like, oh my God, they were so wrong, right? It's so easy with hindsight to say this was such an awful, awful decision. But at least for the next 30 minutes or so, I want you to put yourself in the mind frame of, what if the government's right? What if the government is actually right that there's this pervasive threat of sabotage by Japanese Americans? What if, as the government represents to the court, there was credible intelligence that you had these Japanese people watching the boats, right? And watching the airfields, right? And that they were trying to plot sabotage. And they were trying to engage in war activities on the home front. And you're a judge on the U.S. Supreme Court. And the government's telling you, we need to keep these people locked up. We can't trust them. It's really easy for us to say, wow, Robert Jackson nailed it again, right? Jackson was right. Murphy, man, he nailed it, right? That's really easy. But what's much harder is if you're in the middle of a war and Congress has declared war against against Imperial Japan and Nazi Germany. How do we resolve this one? The case is not as easy as you'd want to think. So the case came up, and there's one issue which the court barely mentions, but they say it at the outset. The 14th Amendment has what's called the Equal Protection Clause, and it guarantees equal protection of the laws. Okay. Now, in 2016, we'll say, well, of course, that means that Congress can't, discriminate on the basis of race. They can't say Japanese people go here and everyone else can stay home, right? She's still not back, okay? They're calling you, yeah. So Tariq, this may be an unfair question, but in 1944, when this case was decided, what do you think the state was of equal protection law in America? How do you think the Supreme Court had recognized equal protection law in 1944? Based on what you know about maybe American history.
Well, I know that we're
Anyone know what I'm talking about? In 1944, yeah.
So this is 20 years before this civil rights. What equal protection? Like what are you talking about?
So Brown v. Board of Education was still 10 years away. Brown v. Board was 1955. So at the time in 1944 when Korematsu was decided, the prevailing standard for protection was a case called Plessy v. Ferguson, which established that the government could treat people separately so long as it was equal. Okay, so the prevailing case was Plessy. So this can be taught as an equal protection case. I don't teach it that way, but it can be taught. And the court makes a note where they say this at the outset. Just flag this for your notes. The court says all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. All legal restrictions which curtail the rights of a single racial group are immediately suspect. What does this mean? The court here was introducing a notion that when there's a classification for people separated on the basis of race, it's suspect, it's suspicious. The courts give it more scrutiny. The courts, scrutinize it strictly. They look at it very closely. Okay, we'll come back to this later. That reason alone should have been sufficient for the court to rule against the government. But they move on. Yes, hold on. That's Zachary.
Okay, so I was wondering on top of the equal protection clause, that seems like it'd be an issue with due process.
Oh, right. Right. What's the due process issue? We haven't really covered due process yet. What's the issue?
Because you're taking people and saying, well, some of these people might be against us, but we're pretty sure most of them are. Like most of them.
Okay, I'll get there in about 10 minutes, I promise, okay?
Yeah.
Yeah, I'll come back to that, I promise. But you're right. So the first issue is the court basically breezes past the equal protection clause. In fact, this is an explicit racial exclusion. I mean, look at the sign. There's no, there's no doubt that this applies to people of Japanese ancestry, right? This is not like a secret one where they're just rounding people up. This is blatantly, right? But the thrust of the court's opinion is this. Who are we to second guess the generals? If the generals come to us and they tell us that there is a distinct threat. And the only way for us to stop this threat is by excluding the Japanese from this region. Again, we're only talking about exclusion here. We're not talking about detention. This is the part that people always miss. There are the three cases: is Hirabayashi, Korematsu, and Endo. We're not talking about detention. This is only about exclusion. If the government says people living near the coast need to be moved inland, right? They need to be excluded, moved inland. Who are we to second guess it? And the majority opinion is by Justice Hugo Black. You recall that Justice Black wrote the majority opinion in Youngstown also. And in many respects, he's being formalistic here, right? The executive power, he's the commander-in-chief, and he can do whatever the commander-in-chief needs to do to protect the homeland. The court also says, listen, we already upheld last year the curfew. If we can keep people in their homes, why can't we keep them out of their home? What's the difference? So the majority opinion, and I don't want to dwell too much time because it's very straightforward and simple. Majority opinion basically says, look, we have to listen to the government here. We can't second guess them. We don't know better. We agree that there's a hardship for those who are detained, but the court writes, quote, under conditions of modern warfare, our shores are threatened by hostile forces. The power to protect must be commensurate with the threat and danger. The power to protect must match the threat. So if there's a threat, the government needs to use the power to protect us. All right, any questions on the majority opinion? The majority opinion, again, it's really straightforward. It didn't take you much time to read. It basically says, we can't second guess the generals. The executive has his power. We've declared war. And as commander-in-chief, he has a full scope of presidential power. Any questions on the majority opinion? Yes, sir.
Quick question. When was the Posse Comitatus Act in place for this number?
It was. What's a Posse Comitatus Act? Tell us.
Well, it pretty much says that the U.S. military cannot be used on U.S. soil.
That's right. So if you're sensing a pattern during the Roosevelt administration, many provisions of law were just chucked out the window. I say this lightly. I mean, various constitutional clauses were excised, various statutes were disregarded, and the president did whatever he wanted. But this is what the majority opinion is embracing. It's like, we are sanctioning this because we're in a time of war. We're not going to second guess what this poster does. Can you imagine walking down the street of San Francisco seeing this poster on the wall? I mean, substitute Japanese for Jews or blacks, whatever it is, right? It's almost surreal to think about. But this was not even 60 years ago, 70 years ago.
Well, it's interesting that it's taking place in 1942. A few years earlier, the same thing happened in Germany. Oh.
Yeah, the closing of the businesses. I mean, right. you see the videos. There's parallels. Yes, sir, John.
So, yeah, I'm trying to understand why the court would just defer as much as the generals and why that wouldn't also set up some other things. At least examine like what kind of threat is commensurate with the power.
Okay, so let me ask you this, John. Right? What position are the justices in to gather intelligence and foreign threats? Remember, I said let's try and defend the judges, right? What position are the judges to gather foreign intelligence? None. Can the government put in their briefs everything they know? No. Why can't the government put in their briefs everything they know?
Because it'll be public information.
And they reveal secrets, right?
Well, then why would you just have, so like the FISA court?
This is long before FISA.
I know.
One at a time, yeah.
I'm saying that they also are cases.
Well, that's why the FISA court was created, so classified information could be considered by the courts. But this case is argued. So now the long and short of it, to John's question, is the government lied. There was no threat. And in fact, in the initial draft of the brief to the Supreme Court, they acknowledged that there was no actual credible threat. The military basically told the Justice Department, you can't write this. So they lied to the court. And about 70 years later, the U.S. Justice Department actually formally apologized to the Supreme Court for lying in its briefs. So the entire case was based on a fiction, right? To the extent that there was a threat, it was in no way commensurate with the actions taken. which makes the entire decision feel much worse than perhaps the first time that you read it. So let's talk about the dissenting opinions, which I think is where probably most of you were interested in. There was one by Justice Roberts. This is not John Roberts, this is Owen Roberts, who was on the Supreme Court in the 1930s and 40s. And he effectively said that this is indisputably a violation of the Constitution, right? It cannot be the law that merely disobeying an order. By the way, there was really no statute here either. This was an order by a general, and unclear what authority was to even issue this, although maybe the Declaration of War provided the authority. But this is a bizarre notion of constitutional law to allow the president to exclude people from their homes without a warrant, without any due process of law, merely because they have a certain ethnicity. Okay. The next dissent by Justice Murphy is probably the one that's most quoted. And Justice Frank Murphy, a good Irish boy, is like, listen, I know this stuff works. This is the ugly abyss of racism. The ugly abyss of racism. That this is straight up racism. And he says this in no uncertain terms. He says, in war, we must accord judgment to military authorities, and their judgments should not be overruled lightly. But the courts existed to find limits on the executive's power. I think this was John's point before. Murphy writes, what are the reasonable limits is something that courts can inquire into. Okay. This is obvious racial discrimination. This rounds people up without due process of law. And this is excommunication without the benefit of a hearing. Right? Let's see. I'll go back there. Sorry. Is that Cindy? Cindy, let me ask you a question. Let's assume for the moment that there actually was a suspicion that Japanese Americans were going to engage in sabotage. How could the government have accomplished their interest without rounding them all up, putting them into camps? What could they have done short of this exclusionary method? Yeah, investigations. And what are you investigating? Yeah, and how could a person prove that he or she is not loyal to the Imperial Japan and is loyal to the Americas? Many of these people are U.S. citizens. Also, they were born here; they're citizens by birth. How could the government have achieved this interest more narrowly? What could the government have done? Now, do you want to take a stab at it? What could the government have done short of exclusion and deportation to figure if these people were loyal to the United States? Just mention one of the opinions. How do you prove someone's loyal to the United States? Yeah, they're American citizens. How do you prove they're loyal? What do you do? I heard someone say it.
Take an oath.
Oath. Oh, you're on the right track. They could have given a loyalty oath, right? And this is actually mentioned in the dissent. You basically make someone take an oath and swear loyalty to the United States. If they refuse, then you can investigate them. I mean, when you become a U.S. citizen, if anyone here has been naturalized, right? You take an oath to the United States to become, a citizen. Yes, sir.
What does that do? I lie all the time.
I'm sorry?
What does that do? I lie all the time. Especially under
Right. So the short answer is giving someone the opportunity to give an oath will allow you to investigate them in a case-by-case basis. Right? Here, this policy was created as a blanket. And I suppose if there was someone they suspected who gave the oath, they can then investigate them further. The difference, though, is that they wouldn't have to have a blanket policy of all people of Japanese ancestry if we're bound by it. Does that make sense? Who should you watch?
I mean, by the theory that one of them is blind, right? Then they would take the oath, and then you're not watching, you're not paying attention.
So was this policy the only way of accomplishing this goal? What was another policy? What could have been done? Well, you said this one doesn't work. What else would work?
I'm not saying I have a better answer.
Okay. Well, let me put it this way. short of internment and exclusion for everyone with a certain ancestry, there were other ways which they could have rooted out the threat. Would that safe say?
Sure.
Okay, good. I'm glad we agree on that. So this could have been done by other means without this massive roundup. The dissent says there's no reliable evidence to justify this blanket ban, right? The government could have achieved this more narrowly. They could have achieved this without locking people up in these camps. Okay. And then we come down to our dissent by our favorite, Justice Jackson, who dissented in both Youngstown and dissented in Korematsu. And Justice Jackson, again, he served as President Roosevelt's Attorney General, right? He worked in the executive branch. He understands how this stuff works. And what Jackson basically says is you cannot have a crime based on your blood. You cannot be born as a criminal. The mere fact that your parents from another country, even if you're a U.S. citizen, you cannot be born. Right? There's actually a clause in the Constitution, which you probably read once when I asked you to, that said that there's no attainder of treason shall work corruption of the blood. What the hell does that mean? If your father is a spy and he's executed as a spy, the child cannot be executed as a spy. The blood is not corrupted. This is in the Constitution. So Jackson says it's impossible to think that the Constitution allows people to be punished merely because of the actions of their parents. Jackson writes, if this was enacted in time of peace, the court would never enforce it. Right? It's indeed not even a law. It's a military order based on a general say-so. But because this is done during a time of war, Jackson writes, the court sanctions it. Okay? And whether the court realizes it or not, and this is probably the important part, they're giving their blessing to this sort of practice. Had the court simply said, this is going to go away in a few months, let's just let this trial play out, there would be no opinion. But here you have this lengthy opinion that's in every single law school casebook in the world, and you guys read every single semester that I teach this class. This is something that people remember. Jackson also says, we have no basis to assess whether this evidence is valid, right? We have no choice but to accept this as valid, and for him, that's not sufficient to justify this. He writes, future governments can rely on this precedent, and indeed, during the Guantanamo litigation, which I won't discuss much in class, there was a big debate about whether the Bush administration would cite Korematsu, and ultimately they didn't. They thought about it, but they didn't. I think they might have said Hirabayashi, but they didn't cite Korematsu. And there's a question of whether this actually justifies subsequent administrations engaging in these sort of detentions. Yep. But I want to stress this point. As easy as it is to praise Jackson, right? As easy it is to praise Jackson, for a moment, if you can, suspend your disbelief and think of what if General DeWitt was correct, and there actually was this threat, and Korematsu was actually a spy. Crazy, but let's pretend for a moment, right? And they let Korematsu go, and they engages in an act of sabotage and blows up a military facility in San Francisco. Then what? What does the justices do now? They go back to their warm chambers in Washington, D.C., and they drink some brandy? These cases are not as easy as they seem 70 years later, and that's the point I'd like for you to convey. So what happened afterwards? Korematsu and Endo were decided on January 18th. On January 2nd, 2 weeks later, Roosevelt rescinded the executive order. So 2 weeks after this case was decided, Roosevelt rescinded the executive order. The internees were given $25 and a train ticket back home. I'm serious. The last clamp, though, didn't close until 1946. And the Solicitor General, the U.S. Department of Justice, basically said that there was no evidence, none, zero, that there were Japanese Americans acting as spies. There was zero evidence. And then in 1983, the government admitted submitting false information to the court. DOJ said in 2001 it was an error. Oh, they got $20,000 per survivor, not $2,000. So each person who went to the camp was given $20,000. Questions on Korematsu? Yes, sir. Hold on. That's is that Caleb? Dylan. Sorry, one off. Yeah, Dylan.
What happened to the property?
I'm not sure, but I'm pretty sure they didn't get it back. I mean, well, if it was a lease, then in theory they would get it back. But if they were forced to sell their business, I think they lost it. Oh no, hold on, everyone, one at a time. Yes, go ahead.
Even the people that leased it, very few.
Do you know that?
Yeah.
Okay, then yeah.
Yeah, because when they're in the camp, they weren't actually able to make like payments on like.
Then it's probably repossessed.
thing,
Yeah,
so,
yeah, that sounds right.
So what happens is it went into foreclosure and a lot of people.
Yeah. Okay, before you guys start packing up, I want to talk about the exam. That's gonna take a few minutes, so this you can stick around for. But yeah, I'll take your questions now. Becker?
My question was also like on top of the due process, would there be, because this is like pre-mixed case, would this be an issue of those retained? They're technically being paid.
An entire class of people. Yeah. No, I think Zachary, that's a fair point, right? There's so much unconstitutional about this, right? I can probably, if they give you a final exam, you can write an entire paper at why this is wrong. But this identifies a specific class of people based on their class. I'm sorry, based on their ethnicity, who would then be removed, taking their property away, forced to sell their property. I mean, this violates like 7 amendments. There's a lot of stuff going on here. So another hand here, yeah.
Yeah, I don't, or not, but I feel like Jackson kind of agreed with Black to the extent that who they didn't question him.
Yeah.
But he just said we should have never said this was okay.
Yeah. Yeah, I think Jackson would just said, just don't take the case in the first place. Yeah, no, I mean, Jackson agrees, is like, we don't know any better, but for him, this was too much. Also, and this is with respect to Jackson, there were 6 votes to uphold it, so his dissent didn't do anything. He wasn't the tie-breaking vote. So he could write his dissent to feel good about himself, knowing that Korematsu will still be locked up. Other question with the Korematsu. I want to talk about the exam in a minute. Yes, sir.
So were there actually these contradictory executive orders where it would violate the
Yeah, so this was a point raised in one of the dissents I didn't have time to mention. But if you think about it this way, there were contradictory orders. One set of orders said that they have to leave their homes. The other set of orders said they have to stay in their homes. You're damned if you do, you're damned if you don't. And this was done deliberately as a trap for the Japanese Americans. Stretching. Sorry. I think it was per person. I might be wrong, but I think it was per. My notes say 20,000. I'm pretty sure it's per person. I have my notes says about $1.6 billion total reparations were allocated. I don't know exactly how that was broken down. I'm sure you can Google that fairly easily. And please tell me what you find. All right, let's talk about the exam. And if you have to go, that's fine. But this will take a couple minutes. I think it's worthwhile. So as indicated on the syllabus on February, I think it's 16th. Yeah. February 16th, we're going to have an in-class midterm. By the way, there's no class on the 11th either. So you have basically a full week to study. It wasn't deliberate, but that's how it worked out. The purpose of this midterm, so early in the semester at class 10, is not to test what you've learned. I know that's going to sound shocking, right? The purpose of giving the midterm this early is to test how you can handle the fact patterns that I'm going to give you. Last semester, I gave a midterm for the first time. This is a new thing the school's pushing on us. So I tried it out, and I gave it roughly halfway through the semester. And by and large, the students didn't study. They didn't outline. They didn't have their notes ready. And I would love to think that you're all different, but I won't. So I will assume that you haven't really started your outlines in earnest. If you have, awesome, but I'll assume you haven't. The purpose of this midterm is to expose you to how my exams look and how the exams are structured. If you go to the syllabus under exam, you'll see 1, 2, 3, 4 exams from the last couple of years and the A+ answer. I also include the midterm from last semester as well. These are available for your benefit. I can't tell you how many have asked, what supplement do I use? What supplement? The answer is none, right? The answer is this class gives you everything you need to know. If you want sample questions, you can look at the old finals exams. My exams are idiosyncratic. They're going to be different than what you'll see in a review book. If you look at a review book, that's fine. It won't help you. But if you look, this is where you need to focus. And I want to show you the midterm from last fall to give you an idea of what's going on. The final exam has 2 questions. Okay, 2 essay questions, 2 fact spotting questions. The exam is completely open book. You can bring whatever you want. You can bring your own outline. You can bring a commercial outline. You can bring the textbook. God willing, you bring the Constitution. I hope you do. Bring whatever you want. It will not help you. It will not help you. And if you're actually finding yourself looking through your notes during the exam, you're doing it wrong. Okay? So bring whatever you want. The exam, the final is 2 questions essay. The midterm will be in class, 90 minutes. You get 1 question. So the midterm is actually half of what your final exam will be. As you can see here, each question has a word limit, 1,000 words. Okay? Why does the exam have a word limit? The simple reason is I want to see what your analysis is. I don't want you to dump everything you know onto the paper, hoping and praying that you veer into the correct answer. That's how I did exams. I was very good at it, right? I could write 3,000 words in an hour. I could just dump everything I know. That's not what this is about. I want everyone to have the exact same space to work with. If everyone has 1,000 words, I can judge one to the next equally, very easily. The word limit, it sounds like a problem. It isn't. Everyone does it just fine. Most people, in fact, last semester wrote below 1,000 words. They didn't even hit the limit. So whatever, right? You can write as much as you want. You can't go over 1,000 words. So it's open book, 1,000 words. The format for each question is going to be exactly the same. Okay? I give you 2 kinds of questions. The first kind of question situates yourself in the year 2016. It'll say, the year is 2016, right? Here's this lengthy fact pattern. What would the Supreme Court do under current law? The year 2016, based on all the cases you know, what's the best argument in favor of this constitutional position? That's the first type of question. The second question, I asked 2 questions in the final. The second question will be, you are at a specific point in time. You are at a specific point in time. It's not 2016. How would this issue be resolved at this point in time? So if you can read this, it might be a little bit small, but I'll read it to you. It says, the year is 1789. You're a clerk to Secretary of State Thomas Jefferson. He's asked you to advise an issue for President Washington. The Supreme Court hasn't even met yet. How does this issue come out? If you haven't noticed, the Supreme Court doesn't have monopoly on interpreting the Constitution. So this question was asking you to focus on text and history of the Constitution, how to resolve it. Okay, it was actually a fairly complicated issue with the war in Spain, which you'll probably be able to understand after we did the lesson today. But the purpose of asking you these questions is to pick specific points in time where there were serious changes in constitutional law. You know, we've done 1936, the time of Franklin Roosevelt. 1955, when Brown versus Board of Education was decided. 1868, when the 14th Amendment was ratified. I'll highlight these points. But there have been certain junctures in American history where a lot of stuff changed. And I want to see if you can understand how the doctrine developed at that time. Which leads me to my next point, how you should be taking notes, which, again, all of you have asked me about, which I appreciate. The way that I would suggest taking notes for this class is to use the syllabus as the frame. If you noticed, and I'm actually very strict about this, each day I cover exactly what I say I'm going to cover. I don't go more, I don't do less. I view each topic as a single unit. There's a reason why I made you read all those cases last week of the appointment and removal power. I didn't want to break them up. It's one cohesive unit of appointment and removal. That way you see, okay, that's Myers, right? That's Humphrey, and that's Noel Canning. There's an arc, there's a connection between the 2 of them. It's very deliberate, the reason why I give the assignments the way I do. It's not haphazard. I won't just say read 30 pages, whatever. It's deliberately designed that way. So your outline should not only track each topic, how did the doctrine evolve? Make sure your outline has the years of the cases, and you know how the cases changed over time. We haven't really done too much about this, but over the course of the semester, it'll make a lot more sense because there are certain points where constitutional law changed quite rapidly. Okay, so for the first type of essay question, it will be current law, the year 2016. For the second kind of essay question, it will be some period in the past. Some period in the past. How can you resolve the law as it existed then? And the difficulty there is you can't cite cases that haven't happened yet. You can't cite cases that haven't happened yet. You know what happened, but it hasn't happened yet, so you can't rely on those cases. This is my way of testing that you actually know the doctrine, right? This is why if you use a commercial outline or Horn book, it'll be worthless, because all they tell you what the law is today. That won't help you at all. In fact, it'll actually hurt you. Because if you start citing cases from 2015 on a case when you're in the 1860s, you're going to get a bad grade. Okay? So the first answer, right? The first answer is, I'm sorry, the first question asks you to discuss some period in the past. Okay? The way I suggest that you approach my exam question, this is my own suggestion, Rebecca may give you other tips, is you first read the instructions. Sounds stupid, but always read the instructions first. That will tell you the exact manner in which I'm asking you about. It will give you the time period, it will tell you the facts, it will even give you the names of the people involved. So you first read the instructions. I know it sounds stupid, people skip it. Don't do that. If you go down to the bottom of the question, at the very end, there are 5 subparts. Each exam question is worth 50 points. 50 and 50 is 100. Easy, right? If the question is worth 50 points, and there are 5 subparts, I'll do the math. Each subpart is worth 10 points. So I grade each question on a scale of 1 to 10. And if you have 1,000 words to answer 5 questions, well, more or less, you should be writing 200 words per answer. It's very logical, I promise. Everything's done in a very deliberate fashion to make this easier for you and easier for me to grade. I like grading to be as fair as possible. And giving these 5 questions makes it very easy for me to compare person A with person B. So the 5 questions that I ask after the exam should be read second. So you read the instructions first, then you jump down and you read the questions. The reasons why you should read the questions is it tells you what I'm looking for. Before you even read the fact pattern, you should know what exactly I'm seeking. Okay? So for example, I know it's small, but I'll read it for you. Did President Washington have the authority to enact this executive order? Did the Spanish Loyalty Act intrude on the president's powers? Right? Was the president's removal of the ambassador constitutional? As you're reading the fact pattern, you should know what I'm asking for. So after you read the instructions 1, and after you read the questions 2, go back and read the fact pattern. This one's fairly short. It's only 2 pages long. There are longer ones. I've had ones that are 3 or 4 pages long. But though they're short, they'll take you a while to read. It's okay if you spend 30 minutes reading the question. If you spend 30 minutes preparing and reading the question, that's okay. Spend as much time as you need to prepare and read the question. Okay? So then after you read the question, then you can start outlining and writing your answer. So that's been the process, and I encourage you to go to Langdell. Rebecca will explain this in more detail. But the short answer is that you should be thinking very carefully about the midterm. And the reason why is the midterm is more or less what you're going to get in the final. 1 second, sir. If you look at the scores from last year, how people did in the midterm, how they did in the final, it's almost a 1-to-1. So if you show yourself that you can demonstrate a good grade in the midterm, you'll do well in the final. If you do poorly in the midterm, you'll do poorly in the final. No pun intended. After the midterm is given, I will do my best to grade them as quickly as possible. This is a section of 85. I have 80 in my other property sections, so about 150 to grade. These are time-consuming, but I will do my best to grade them as quickly as possible. And that way, there's time for you not only to get your grade, but to have feedback and meet with me. If you get a C- or lower, you're required to meet with me. Others, it's optional, although it's something that may be worthwhile. If you get an A, keep up the good work. Okay, that's the general frame. I encourage you to go to the syllabus when you get a minute and scroll through all. That's not it. Scroll through all of the old exams. look at the A+ answers, and that will tell you what I'm looking for. Again, this class is entirely transparent. It will be very easy for me to not publish my exams. That way I wouldn't have to write new ones every year. But I publish them. I write a new question every year based on what I taught in class. Every year, as the video watchers know, I do things differently. It's not always the same. And the things I focus on are not based on whatever I feel like, but the exam is based on whatever I covered this year. 3. It's open book. The Constitution's right in your pocket. But you need to know where they are, right? You don't have to memorize the Constitution. I haven't memorized it. But if you're talking about the executive power, you should know it's somewhere in Article 2, Section 2. Guys, you can just pack up a minute. It's okay. Respect for your classmates. Yeah.
Are we allowed to bring in cases we have not covered in class?
Don't do that. Why would you cite something we didn't cover?
My second question.
Yeah.
Why aren't we going over devs? Just out of curiosity.
We have a lot of stuff to cover. Yeah. I mean, we have a lot of stuff to cover. We can't cover everything. Yes. Yes, the midterm we grade on the same curve as the final exam, and that's the school's official curve. In the back? Everything's completely open book. Bring whatever you want. It won't help you. It really won't. Other questions?
With regard to using our constitutions on the exam, do you want us to just reference Article 1, Section 2, or do you want the actual language?
You can cite the clause and verse, and that's good enough. You don't need to quote it. You have a word limit, so you don't need to waste words. Yes, sir.
If you ever ask like what a specific justice would respond to, it'd obviously be like one of the bigger ones or more well known.
Yeah, that's fair game. Your hand up? No, you do need to know the justices because it will come up. If you look to my old exams, see how I do it. Anything else? Oh, I apologize for keeping you late. I think that was worthwhile enough, and I will see you all next week. Thank you.
Here's the roll sheet.
Thank you, sir. Yes, ma'am.
Are you familiar with the Man in High Castle?
Yeah, I mean, I haven't watched it, but I think I saw a trailer for it on Netflix. I haven't seen it
Well,
yet.
there's a book as well.
Yeah,
and
no,
it's
I know.
very much based on that part of time.
Yeah,
So I
because
just
basically
thought that might be interesting.
Yeah, because basically the Japanese won the Eastern.
Right, FDR gets assassinated, and so we end up losing World War II.
Yeah,
and,
interesting.
The Japanese take the West Coast, and
Yeah, they just splice up
yeah,
the middle,
right.
Yeah, no, I haven't seen it, but I heard about it. So is it good?
I like it. I think it's really interesting.